In March of 2021, people entered a private security deposit box company in Beverly Hills, California, broke open hundreds of boxes, and indiscriminately seized their contents, collectively worth over $100 million. Box holders lost their life savings, family heirlooms, important documents, and more. But the people who took their property weren't mobsters. They were FBI agents. I'm Kim Norberg of the nonprofit civil liberties law firm, the Institute for Justice, joined by co-host Keith Neely. Today we have with us IJ attorneys Bob Belden and Mike Greenberg. They're going to share with us the story of an unprecedented FBI raid and how the Institute for Justice is making sure it never happens again. This is Beyond the Brief. So Bob, how did all this start?
This all started with a company called U.S. Private Vaults, and that was a private safe deposit box company in Southern California. And it was used by a lot of people to store cash, valuables, that kind of thing, people who value privacy. Now, for example, our client Linda Martin in one of our cases, she used it because she looked for a box at like her bank but couldn't get one, and found U.S. Private Vaults and liked that, like, it had the really fancy security technology, kind of like a fingerprint and eye scanner, I guess, and it was open 24 hours a day. So if Linda or her husband, who were saving money if they needed it, they could always go. And they also liked that it was kind of far across town. They wanted to be able to get it if they needed it in a pinch, but it was far enough away that, like, they couldn't just go and grab money all the time, and Linda was worried if she had a debit card, she'd just spend it all. And, you know, sometimes when you're dealing with people storing cash, like in a safe deposit box, you have to fight this urge that it's odd because some people find it hard to understand. And we kind of fight against that current in this case because a number of the people who were using safe deposit boxes at U.S. Private Vaults were thought by law enforcement to be involved in criminal activity, as was U.S. Private Vaults itself. Unbeknownst to Linda and our other clients that we're going to talk about, U.S. Private Vaults was being investigated for fraud and sort of financial related crimes. And while Linda and her husband were looking for a place to store their money, they had no idea that one day the FBI would come to perform a raid at U.S. Private Vaults, which it did in early 2021.
Well, let's pause there for a moment. So the FBI thinks that there's something fishy going on at U.S. Private Vaults. What do they do next? They want to search the place. Do they apply for a warrant? How did they do it? What happened? How did we get from, hey, this is suspicious, to, okay, let's storm the place?
Yeah. So I might have to let my colleague Mike Greenberg here jump in because I think he's a little more familiar with the warrant, but I am comfortable saying they overstated what they were doing.
That's exactly right. The FBI applied for a warrant to search and seize the premises, the business of U.S. Private Vaults. It wanted to shut the business down on the theory that the business itself was engaging in fraud or other criminal activity. And so it applied to search and seize the business's property, and that included the nest of the safe deposit boxes that housed the safe deposit boxes. It did not include a request to search or seize the contents of the boxes itself, and for good reason. The FBI didn't have any probable cause to suspect that any of the box owners themselves had engaged in criminal activity or what they had done wrong. And so there's this kind of tension in the warrant application where the FBI is going to seize all of the business's property, and then the boxes are just going to be left behind. And so there's this problem they have where they have to tell the magistrate, we are necessarily going to come into contact with these boxes, but we don't have any probable cause to believe that any of the owners have done anything wrong. So what we are going to do is we are going to only open the boxes as far as is necessary to identify the owners and return their property to them. If we need to open the box in order to identify the owner, we will simply inventory all of the property to make sure that we are not liable for claims of lost or stolen property or anything like that. And then they just simply would not search or seize the box's property or the box owner's property for a criminal search.
So that's what the FBI said. What actually happened on the day of the raid? Because I understand that what the FBI promised and what the FBI delivered were two very different things.
Absolutely right. Over the course of 4 days, a swarm of FBI agents from 2 other federal agencies, and from all sorts of local law enforcement agencies as well, break open every single box at U.S. private vaults. And for a overwhelming number of boxes, that was entirely unnecessary to begin with, because U.S. private vaults instructed its customers to tape an emergency contact form onto the top of the box for precisely a situation like this, where you have to get in touch with the box owner or their emergency contact in order to identify them. So for the vast majority of boxes, there's no need to open the box at all. The FBI blows right past those emergency contact forms, and for every single box over the course of 4 days, it breaks every single box open, and it doesn't stop when it can identify the box owner from the contents of the box. It goes through every single item in there. It holds them up to video cameras, it holds them up to photo cameras, and creates these records of everything that is going on in the boxes. And these are incredibly personal things that are in the boxes. There are things from cryptocurrency passwords to the cremated remains of someone's relative. The FBI creates records of all of those. And as for cash, anytime it finds cash in a box, it runs that cash through a drug-sniffing dog. How that helps you identify the box owner is still a mystery to me. And as far as it is actually inventorying the property inside of those boxes, the records it created are useless. Anytime it found cash in a box, the FBI was not documenting how much cash it was. They just simply wrote on their forms U.S. currency. For things like jewelry and coins like gold and silver, they would simply write miscellaneous coins or assorted jewelry. Some of these entries are as vague as assorted general items and things like that. So everything that the FBI said in the warrant it was going to do, like create an inventory if it needed to, it didn't do. And everything it said it was not going to do, like conduct a criminal search or gather information for possible crimes, it did do, like running cash past drug-sniffing dogs.
And, they ultimately took a bunch of this cash also, but what are we talking in terms of numbers here? How many boxes, how many dollars worth of property?
In total, there were over 700 boxes at U.S. private vaults. And as we'll get into in a minute, the FBI eventually tried to permanently take up to $80 million in cash and well more than that in jewelry and coins and other valuables. It was a lot of property. This was, as we like to say at IJ, this was the largest armed robbery in American history. And the perpetrators were the FBI.
Well, it strikes me two big themes come out of that, at least for me as kind of a lay observer. One is, okay, you have the FBI who's now exceeded the scope of its warrant requirement. That's a huge issue, right? The second, and this is relatedly, is how systematic it was. Because we're talking about drug-sniffing dogs. We're talking about, these different processes that the FBI followed. I understand that there were supplemental search instructions that were part of this case. How did the FBI try to, systematize this, I guess, is what I'm getting at.
Well, I think Mike has talked about it a little bit already. The instructions about, when you open a container, take a step back, and I think Mike makes the point already, but what's the safest way to make sure the contents of a sealed container don't get out? Just leave it sealed.
Don't open it. Yeah.
Just wait till you know who you're going to be investigating U.S. private vaults. Just leave it until you know who it belongs to. They didn't decide to do that, and instead they systematized the steps that they would take after they cracked it open, and that includes organizing in advance to make sure that the drug-sniffing dogs were there, and preparing supplemental instructions that kind of supplemented the normal inventory search. And I think that when you take that kind of forethought and are looking sort of with knowledge that you're going to be going in and conducting a criminal search, it takes it sort of out of the realm of other cases we are currently litigating that involve forfeiture, which typically involve law enforcement, reacting to some sort of percipient action, whether it's a traffic stop or an arrest, and making a determination that certain property is subject to forfeiture kind of on the fly. The case with Stephen Lara is a great example. Anybody who has seen the case video can see the Nevada Highway Patrol officer sort of working through things in their mind, like, can we take it for this? I don't know. Can we do it for this? When you lay out instructions in advance for your officers and your agents, you can kind of know, oh, okay, this stuff will be subject to forfeiture. This stuff won't. And I know that we are talking about forfeiture kind of a lot, and I'm sorry to our viewers. I'm sure many of them know what forfeiture is, but for those that don't, it is a legal doctrine in the United States, which, like most good legal doctrines, started with the pirates, and it basically allows the government to pretend like property is guilty of a crime and to take it without actually proving any individual, including potentially an innocent owner of the property, committed a crime. And what we'll be talking about today are kind of two variants of forfeiture at the federal level. There's civil forfeiture, which is, even though it doesn't have the kind of trappings of criminal law you'd expect, like beyond a reasonable doubt, the right to like cross-examine witnesses and, that kind of a thing, you get a judge and at some point the government has to produce evidence, presumably of something. We don't like that. We don't like civil forfeiture because of the innocent owner and like various other issues with it. But it is worlds better than the other thing we'll be talking about, which is administrative forfeiture, which is something that the good folks at the FBI or ATF or any other federal agency that's involved in law enforcement can do in-house. And those processes are totally unreviewable at the judicial in the judicial world and have no standards. So you're basically at the whim of the agency. They get to tell you what they want to tell you about the forfeiture. They get to decide when they want to decide, and they get to decide how they want to decide. So we have taken to calling administrative forfeiture sometimes take now, explain never forfeiture, because you can be in it for years and never know how you got there or why you're losing.
So when news of that first case first broke, the FBI portrayed it as sort of a major victory against, organized crime and things like that. How did that play into how we had to talk about the case after?
So when this news story broke and all of the box holders are finding out about this through the news, they're seeing images of the raid on TV and being covered in the Los Angeles Times. And a lot of the media is taking what the FBI is saying kind of at face value, that they took down this business that was helping shelter organized crime, that all the box holders were using this kind of very private, high-tech, secure business for their drug-related crimes or money laundering crimes. And it was really scary for all of the box holders that, like our clients who were totally innocent of having done anything wrong. A lot of the early cases that were filed were one-off cases, people who were filing cases in the name of John Doe. They were terrified of going up against the FBI and its narrative. All they wanted to do was just get their property back that had been seized as quickly as possible. And it was really difficult to find clients who were willing to stand up to the FBI and say, no, I'm innocent, and I'm going to put my name and my face out there so the real story about what's going on here can be told. We at IJ interviewed a lot of people that were scared of that, and it was not until we interviewed our fantastic clients Paul and Jennifer Snitko that they kind of broke the dam and said, I'm willing to stand up for what is right. I'm willing to put my name and my face out there and say, no, the FBI is wrong. And that allowed other clients to join them, their bravery. And it allowed us to file this case as a class action on behalf of every box holder whose property had been wrongly searched and seized.
Is this a tactic that you find the FBI engages in often, as in using civil forfeiture and trying to use perhaps the stigma of perceived connections to criminal activity to intimidate people into silence and not stand up and challenge them when they do things like this?
Yeah, and more than that, I mean, when you get involved in forfeiture, the way it basically starts, and I think we'll talk about this in connection with one of our cases, but you get a notice from the federal government that says, hey, we have your property. Why don't you tell us how you want to get it back? Is it yours? Why don't you prove it? You subject yourself. I mean, anything you submit in response has to be submitted under penalty of perjury, and anything you give them can be used not only to justify the forfeiture of the property they already have, but to justify further criminal investigation of you and further forfeiture of further property belonging potentially to you and to others. So it is quite the cudgel for the federal government.
So as the case progressed, it turns out that what the FBI did was even worse than we thought that it had been at first. Can you talk about that a little?
Yeah, so Mike and the other folks on the first case team did a great job holding the government's feet to the fire in discovery like we normally do, and they got a bunch of evidence that showed that, I can't remember if it was before the government applied for the warrant, but it was definitely before the raid. The government had made the determination, and it might have been in the supplemental instructions, but it had made the determination that any box with more than $5,000 cash was going to be forfeited. And it didn't, obviously at that time know who owned the box. So it couldn't, just as a matter of logic, could not have suspected that person reasonably of criminal activity, and thus could not have had any sort of basis for seeking a warrant to take that money, right? But it had already made the determination that the money was subject to forfeiture, which I think, as I mentioned before, requires proof that the property is connected to a crime.
So they were basically saying, if we see money, we're going to take it. We don't know who it belongs to. We have no idea if they've done anything or not. We're just going to take everything we see, figure it out later. Exactly.
And so as the case is progressing and sort of more clients and more people are learning about this mass seizure sort of every day, as Mike mentioned, it was on the news. Our client, Linda Martin, learned about it on the news. She shouted at her husband, Reggie, that's us. That's our place. But as more people are learning about what happened, we got in touch with the lead plaintiff in our second case that came out of this raid, and her name is Linda Martin. I've mentioned her a couple times already, but she and her husband, Reggie, live in Southern California and had been working like in 2019 to 2021 timeframe. They had met and were saving up money to buy a house in Southern California. And they were like living rent-free with one of their family members and just saving a bunch of cash. And somebody was like, hey, not a good idea to have a bunch of cash just sitting here. Why don't you put it away? And so they started looking, as I mentioned, for boxes at their local bank, but they weren't available. So they wound up at U.S. private vaults. They save up over the course of 2 years a little bit more than $40,000 to buy a home. And so I know interest rates have gone up a lot since 2019 and 2021, but at the time that 2.75% interest rate, they were going to make a down payment on a house. But they found out watching the news that the FBI had taken their money.
Did you know IJ represents ordinary people, free of charge, as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
just to jump in there really quick, it's got to be insane to just be watching the news and see, oh, our entire life savings, everything we had been saving for this house is gone, right? Like, that's just got to be such a surreal experience, and it's like, that just feels gross, but surely it's also unconstitutional, right? Like, there's got to be a constitutional problem with that. What's the sort of legal issue there?
Yeah, so the legal issue is that after they learned about the seizure and they got actual notice, so they ran down to U.S. private vaults and confirmed that the money had been taken because it was surreal. They wanted to make sure it was actually happening. What happened next was they got a notice from the FBI that is basically, you can think of due process in the United States, right? That principle at its core says everybody who's sort of at jeopardy of losing life, liberty, property, you get notice and a meaningful opportunity to defend yourself. When the FBI took Linda's money, we've already talked about, they knew she had more than $5,000. That was it. So they took her money. They sent her a notice that was supposed to tell her, hey, here's why we took the money. This is the federal crime that we think was committed. Here are the facts that connect you to that federal crime and sort of give rise to our belief that this property is subject to forfeiture. But what the FBI does instead is, through a sort of cut and paste process, sends out essentially template notices that say, we have your property. It was taken on this day from this place, essentially because somebody committed one of hundreds of different and widely variable federal crimes. So you're basically left in the dark and said, pick how you want to try to get your money back. And so we filed a lawsuit on behalf of Linda and everybody nationwide who has received one of these notices from the FBI.
Let's take a step back to that notice real quick. So when someone gets a notice like that and they're told, we took your property, you could have committed any one of hundreds of federal crimes, what are their options to proceed? What decision are they making at that point when they get the notice?
Yeah, so at that moment, they have to decide between submitting a claim, which initiates the civil forfeiture process in federal court, or submitting a petition for remission, which goes to the agency, in this case, the FBI. And it is not the sort of core of our claim in the second case, but there's definitely an element of due process that is influenced by the fact that the notice's description of those two options is extremely confusing and, in my view, designed to lean towards the petition. And that is critically bad for innocent property owners because, as I mentioned before, the administrative forfeiture process, if you go into it, you're locked in. It's an unreviewable process. You can get to the end and ask a court to look at whether or not you physically received a notice and knew the FBI had something that belonged to you. But other than that, you can't get a review at all. You don't have a timeline for a decision, and there's no way to know that any of the evidence that you might submit is actually going to be considered in returning your property.
And isn't by submitting a petition for remission, isn't the property owner effectively conceding that the FBI has the right to take the property? They're kind of saying, hey, can you please give this back to me, pretty please?
Yeah, that's right. That is, I'm glad you mentioned that because that is sort of the worst thing about it. It's, yeah, you guys can keep it, but please give it back to me. And
do me a favor and give me back the stuff that's now yours.
Right. And that's, when you say it like that, it seems ridiculous that you would ever choose it. But this notice form is I think it's about 2.25 pages. And that remission section is the only one that talks about getting your property back. When you read the bullet points about filing a claim and going into civil forfeiture, it's like, I've got to get a lawyer. I got to go to federal court. There's going to be a U.S. attorney involved. Sounds like a pretty burdensome process just to show up and say, like, hey, you guys got my money and I don't know how it happened or why, but could I have it back? Which is, incidentally something I know Linda tried to do, like, just informally contacted them like, hey, I think you've made a big mistake. And they say, oh, yeah, we'll get to you.
We'll work on it.
And then
we'll work on it.
They sort of never do.
It's surprising. So crazily, that's not where this ends, right? There's another case because the FBI then loses or damages or something, a bunch of stuff. So what happens to kind of all of this property once the FBI takes it?
So once the FBI takes it, they, as Bob said, send out this omnibus forfeiture notice where anything that's worth more than $5,000 that they kept track of, they are trying to forfeit. The problem is, as we were talking about earlier, their inventory procedures were so convoluted and not quite all that good at documenting exactly what they were taking or what they were inventorying that naturally over the course of 4 days and 700 boxes, some of this property is going to go missing as you combine all that together. And that's what happened to two of our clients in a third case. Jenny Pearson's and her husband had a box at U.S. private vaults where they kept both silver coins and about $2,000 in cash. And after we thwarted the FBI's forfeiture plans for their silver coins, Jenny said, well, where's the cash as well? And they said, oh, well, we don't know any cash. There was no cash in the box at all.
Yeah. And so they're just basically pretending that Jenny never had any cash at all. They never wrote down on their thing, random bundle of cash. So that's just gone.
Exactly right. And in another client's case, a guy named Damayan, he had thousands of dollars of valuable coins as his retirement nest egg in his box. And those coins have gone totally missing as well. It's astounding that after 4 days and going through all these boxes that these pieces of valuable property are just gone. When in both of their cases, there was no need to open the box in the first place because both of them had their emergency contact information on the top. In that third case, we are now suing for the FBI to compensate them for the property that they lost, which is what they told the magistrate they were going to do in the first place, and was the entire reason for the inventory.
So how does that work in practice, right? The box owner is saying, hey, I had 50 something coins and $2,000 and whatever. And the FBI is saying we didn't write it down on our piece of paper. How does this just come down to ordinary American says X, the entire FBI establishment says Y, I wonder who's going to tip the scale, right? Like how do you kind of tease out what was actually in there? How does that work in court?
Well, for Jenny's purposes, at least, she had photographs from just before the raid actually showing that there was cash in the box. And so I think that's going to help a good deal in her case. As for everything else, I think it's the case that there's a lot of he said, she said cases in the American justice system every day. The courts are going to have to weigh the testimony and the evidence as to who they find credible. Given that in our first case, the FBI has already been documented as being on record as having misled the magistrate in applying for the warrant and concealing their plans from him for all this forfeiture activity, I'd like to think that the courts are not going to look too kindly on the FBI's he said in this case, but I suppose that we'll have to see to find out.
So what's the current status of all of these different cases?
So as for the first case is over. The Ninth Circuit Court of Appeals ruled resoundingly that the FBI violated the Fourth Amendment in conducting the raid, the search, and seizure at U.S. private vaults. A 3-judge panel agreed that the search could not be justified under the inventory exception to the warrant requirement because the FBI didn't use or make a useful...
Didn't make a real inventory.
Didn't make an inventory at all. And in fact, the fact that they used those special procedures that were not the FBI's ordinary inventory procedures was one of the deciding factors in that. A majority of the court also found that the FBI violated the terms of the warrant by concealing their forfeiture plans from the magistrate and by not saying that they had made these special instructions and by conducting a criminal search or seizure, which was plainly forbidden by the warrant. The fact that they ran all the cash by the drug-sniffing dog is only explained by the fact that they wanted to criminally search that property, and the fact that they had before the raid, before submitting the warrant, had already planned to forfeit everything worth $5,000 or more, and did not disclose that to the magistrate, was frankly something that the warrant almost certainly would not have issued if the magistrate knew about that. And one other note, if I may, on the $5,000 point, some listeners may be wondering why $5,000. As the FBI explained to us in discovery, that is the minimum monetary threshold that they've established that would ensure that they get money on the deal. That's how much it costs them on average to kind of go through the forfeiture process, do all the paperwork, all of that sort of thing. And so if it was under $5,000 and they weren't going to get a net proceed out of it, they weren't interested. Above $5,000, and they were. So that's where the first case is at.
Then the second one on behalf of Linda, we brought it. The first one's in federal court in Southern California, or well, that's where it started. We brought Linda's case here in the District of Columbia, and we did that because this is where the FBI is. But the district court for the District of Columbia granted the government's motion to dismiss, which is basically like even if everything you say is true, so what? I heard that articulation on advisory opinions the other day, and I thought it was pretty good. So the trial court granted that motion, but what it did, so it ignored one thing from the first case that we relied on pretty heavily, which was the first court granted a preliminary injunction against the FBI forfeiting our client's property because the notices appeared to be deficient under due process. And that's, basically the claim we brought on behalf of Linda and a nationwide class. When the court dismissed our claims, it didn't consider that order or any of the cases that order relied on. So what we're doing now is appealing the case to the D.C. Circuit Court of Appeals. And I think that is where the case stands. But, happily, sort of as a human matter, Linda and Reggie have their money back. It sort of, it's good for them, but it also highlights, the pernicious nature of the game that law enforcement often plays. To give you a rough sense of the timeline, they take Linda and Reggie's money in March of 2021. They held it for over 2 years before giving it back, but they gave it back about a month after we filed our lawsuit, saying that they had violated due process in the way that they perform this function on a nationwide basis. So it's sort of, we felt like it confirmed that we had touched on a touchy subject, but they gave the money back. So Linda has it, but we are continuing to appeal for her and for the absent class members.
And in fact, in giving the money back, the FBI tried to use that to argue that Linda's case was moot, right?
Right, yeah, which is basically, folks probably know what that means from context, but if you're playing keep away and someone sues you to get it back and you give it back, you'd like to think there's nothing more for the court to do, but there is a doctrine, I think it's called voluntary cessation. Government's not allowed to do that with people when it's taking property
because it's
giving
gaming
it back.
The system, right?
Yeah, absolutely. It's you're caught with your hand in the cookie jar, and you want to avoid responsibility. And it is it's an oddly sort of calculated decision. Mike makes the point about the $5,000 threshold. Much of this is how much can we add to our coffers, and how much delay is this going to be? And it's like you get sued in a nationwide class action, and your first impulse, give the money back.
Away.
Just give the $40,000 back.
Yeah. So how is this raid sort of different from a typical forfeiture case? You mentioned Stephen Lara, and somebody like him is kind of more what we're used to seeing in sort of the civil forfeiture context. So can you kind of do a bit more of comparing and contrasting?
Yeah, this is, as far as I'm aware, at least in my time at IJ, the only case I know of where somebody had sort of entered into a commercial transaction to store things in this manner, and that itself was used as evidence to give rise to an attempted forfeiture. And so it is different from the cases we normally see where, somebody is just driving and they get pulled over, and unbeknownst to them, they are violating some sort of traffic law, and you're off to the races. Or they lend their property to somebody else and it gets taken in when that person's arrested. Those things, like I mentioned, they sort of happen when you don't really know how they occur in the moment, but like you understand you gave your car to your cousin and now the car has been taken, right? You gave Linda, for example, gave her money to a company after, signing papers and, thinking that that company had property rights, and all of the sudden her money was gone. And so it is different, but I think it's a logical extension from the government's point of view of the permissive hand that they've had in much a forfeiture world over the past couple decades.
Well, and let's talk about the government side of that, because you mentioned in sort of Stephen Lara's case, the police officer kind of trying to walk through, I see this cash here, how do I take it? And he's sort of creating that framework kind of on the fly in the moment. And that's generally how this sort of thing works in our experience, but that's not what happened here, right?
Right. Yeah. I mean, it reveals kind of the thin veneer that is the idea that forfeited property is actually connected to a crime. If you can set out on the front end, you're the law enforcement officer, you set out on the front end to just take property based on its value and its location somewhere, you're not getting there and actually using your law enforcement discretion or skill to observe, is this the drug lord's private jet, or is it the single mom's car? That's something you can do in person. But if you show up and you've got instructions from the brass, take everything over $5,000, you're not really investigating or enforcing. You're sort of processing a property transfer, and it's divorced from the idea of law enforcement, in my view.
So clearly, the FBI engaged in a wide array of wrongdoing in this case. We filed now 3 lawsuits. Who knows how many more are to come down the line? What's the goal here? What are we trying to accomplish in suing the FBI about the USPV seizure, about its ongoing retention of the property, about the notices that it's giving? What's our goal?
So in the notice case, our goal is to force the FBI either to cure the notices that it has sent to everyone in the country over the past 5 years, or return the property. So it's, this system has brought the federal government like over $1.1 billion from 2017 to 2021. And we want to throw a gum in the works for the FBI and say, you need to state the specific facts and the specific law that underlie your taking of this person's property, or you need to give it back. And we think that we think, given our experience in U.S. private vaults, that they very likely cannot do the former. And so we want to stop the administrative forfeitures that are happening there now until these notice issues are cured.
And as for the actual raid side of things, the Ninth Circuit gave what the Wall Street Journal called a spanking to the FBI. And we hope that judicial spanking yield some contemplation on the part of the FBI or from DOJ to the people who greenlit this raid from the outset. And certainly we hope that the Ninth Circuit's opinion is a cautionary tale to any agent that would dream up this kind of widespread, systematized theft of people's property to never do it again, because you're going to get judicially spanked.
Is it fair enough to say that this was sort of I don't necessarily want to say that it was like a novel or experimental procedure on the part of the FBI, but is it fair enough to say that if they had gotten away with it, they would have done it again? And the fact that we filed these cases and, gotten these victories so far and all of that, does that sort of change how they think about this at all and kind of discourage them from ripping people off on a grand scale and, running away?
I certainly hope so. I certainly think that if they had gotten away with it, then they would do it again, because why not do things that if there are no consequences for doing them? It's a plus for us that after oral argument at the Ninth Circuit in the first case, the government got such a berating from the three judges on that panel that after oral argument, but before the opinion issued, the government fully conceded that we should win. The court should enter all the relief that we were seeking. We think that's a win in and of itself, that there's some contemplation on the part of the government. And we certainly hope that the opinion that eventually did issue is a telltale sign. The Ninth Circuit's opinion compared the FBI's practices to the writs of assistance that sparked the American Revolution. If that's not a warning sign, then I certainly don't know what might be.
So just to wrap things up, what's sort of the, long-term vision here? Are we, and how close are we to achieving that vision? Are we just trying to get rid of civil forfeiture across the board? How do we get there?
I think that's certainly one of the end goals. I think that we are trying to attack civil forfeiture from every which angle that we can. The notice case that Bob is spearheading is one such example. There was a recent case at the U.S. Supreme Court in which two of the justices heavily suggested that they are interested in curtailing the profit motive that is inherent in civil forfeiture. The ultimate end goal is to end civil forfeiture and replace it with only criminal forfeiture. That is forfeiture that you must be convicted of a crime in order for your property to be taken permanently. Until then, we're going to keep attacking civil forfeiture from every which angle we can until we can get to that goal.
Thanks again for watching today's episode. We got a lot of great comments on our episode about Bivens and qualified immunity, so let's take a look at a few. Jeremy writes, anyone that takes an oath to the Constitution should be liable for violating it. That's absolutely right, Jeremy. That's why we at IJ have launched our project on immunity and accountability. If everyday citizens are expected to follow the law, government officials should follow the Constitution. Franimus writes, can any judges be sued for willfully misinterpreting laws in Supreme Court decisions? Judges can't be sued for misinterpreting the law, but their decisions can be appealed to a higher court if one exists. The challenge is that some courts, like the United States Supreme Court, have what's called discretionary jurisdiction. That means they get to pick and choose the cases they hear. Because those courts hear a limited number of cases, they can't correct every legal error that a lower court judge commits. That's why we at IJ try to bring multiple cases about the important issues. No lawyer can win every case, but we found that lawyers who patiently, persistently, and persuasively argue for the right interpretation of the law will eventually win and make the world a little better. Robin Cross writes, what is a cause of action? Well, great question, Robin. A cause of action is a legal term of art that essentially means the right to sue someone for relief in court, usually for money damages. The Supreme Court has held that the right to sue someone is separate and distinct from the substantive right itself. Somewhat paradoxically, this has led courts in some cases to conclude that a person's constitutional rights were violated, but that no cause of action existed that would allow them to sue in court and obtain a remedy. We think that's wrong. As Chief Justice John Marshall famously observed over 2 centuries ago, where there is a legal right, there must be a legal remedy. Otherwise, our rights become unenforceable paper promises. Druber writes, so what really were the consequences for Heather personally in this suit? She's still an officer, so she didn't lose her job, and the taxpayers paid the victim $185,000. That's my issue. When you sue anyone in government, local, state, or federal, the taxpayers end up having to pay for the official's wrongdoing. Hence, why they continue to violate the rights of the people. You're spot on, Drew. In a world where doctrines like qualified immunity protect government officials when they blatantly violate people's constitutional rights, there is little incentive for government to start acting better. Officers like Heather Weicker continue to remain employed, and they often continue to violate people's rights. The only way that will change is if the law changes. Congress has the power to do that, and we're constantly bringing new legal challenges in the hopes that the Supreme Court will start to curtail these government-friendly doctrines. But change can also happen at the state and local level. To that end, IJ has launched Americans Against Qualified Immunity. AAQI connects grassroots activists with resources and opportunities to contact their elected representatives to encourage them to pass reform at the state and local level. We've also created model legislation that states and cities can use to open their courthouse doors to victims of government abuse and allow them to hold officials accountable. If that sounds interesting to you, check out our website at aaqi.org. Thanks again for watching, and make sure and tune in to our next episode.